My name is Professor Dan Kaufman, and you're watching the MLS network. After you're done picking the jury, the judge will then swear the jurors in and give them a bunch of instructions. Then they'll take a break, and the judge will then begin the trial. The first time that the lawyers are involved in the trial after the jury selection is what's called opening statement. The opening statement will take anywhere from 15 minutes to a couple of hours, depending on how complicated the case is. It is the only time besides closing that you address the jury. There is no communication back and forth like there is in jury selection, but all there is the lawyers talking to the jurors to educate them on a couple of things. One, who the witnesses are and what the witnesses will say. Two, what the issues are in the case. And three, what the other remaining evidence is going to be. How this is done is usually like in a storytelling fashion. The jurors will sit and listen, and the lawyers will either use PowerPoint, will use various exhibits, can use sketch pads, boards, x-rays, you name it, anything at all to keep the jurors' attention and to tell them and educate them about the case. It's also compared to the movie trailer at the beginning of a movie, let's say, where it shows you what's going to happen, or scenes from next week after any TV show. That's kind of what the lawyer is doing, presenting it in the light most favorable to their clients without arguing. The name of it is opening statement. There is no argument permitted, unlike the end where it is closing argument, where there is argument. What usually happens is that the lawyer will stand basically in the dead middle of the courtroom. There will be the 7 jurors. In some states, the states differ in the number, but in some states there's 6 jurors plus an alternate. So there'll be 7 jurors sitting listening to you. And you'll either have the blow-ups and a big screen right next to you, and then you'll have this uninterrupted time, unless the other lawyer objects to something that you say. You'll have an uninterrupted time where you're talking to the jurors about the different things. A lot of lawyers will walk the room and simply go juror to juror making points. There's a lot of hand gesturing, and there's a lot of effort to make eye contact to build the credibility of the lawyer along with the credibility of the case. So that the jurors, when they leave the opening, your goal is that you're winning. You no longer want to be even. If you're losing at the end of opening, in other words, the jurors have already begun to form an impression against you, you have a very difficult job to convince them otherwise during the course of the trial. At the end of the opening, the plaintiff goes first and the defendant goes second, usually. At the end of those things, the judge will then take a break, and the beginning of the evidence, the commencement of the witnesses, will be the next part of the trial, which is what we'll talk about next. My name is Professor Dan Kaufman. You're watching Mr. Law School, but you should be studying.